Welcome back to the Deep Dive. Today we're getting into a really significant Supreme Court case, Bucklew v. Precythe.
That's right. We know listeners are interested in these complex legal issues, and this one hits a fascinating spot, Eighth Amendment rights clashing with, well, the mechanics of capital punishment.
And just to start with the bottom line, the Supreme Court ultimately sided with Missouri, upholding their lethal injection method in this specific case.
Right. So knowing that outcome, our mission today is to really unpack the arguments. How did they get there? What did each side actually say before the justices?
We'll look at the petitioner, Russell Bucklew, and the respondent, the Missouri Department of Corrections.
Exactly. Lay out their core contentions.
So the central question really was this: would Missouri's plan to execute Russell Bucklew using lethal injection count as cruel and unusual punishment, violating the Eighth Amendment?
And the whole reason this came up was because of Mr. Bucklew's medical condition, very rare cavernous hemangioma. He had this significant tumor in his throat.
Okay, so the petitioner, Bucklew, his argument was basically that this condition created a substantial risk of really severe pain and suffering during the execution.
Yeah, multiple potential problems. Difficulty getting the IV in, the risk of his airway collapsing, bleeding, just the general distress his condition could cause during that whole process.
But Missouri, the respondent, they pushed back. They argued their protocol, the steps they follow, plus the doctors involved. It was all enough to handle his condition.
They essentially said the evidence just didn't support Bucklew's claims of constitutionally forbidden levels of suffering.
And Missouri also leaned heavily on previous Supreme Court cases, right?
Absolutely. Baze and Glossip, those are key precedents for how you challenge an execution method. And Missouri argued Bucklew failed a crucial test from those cases.
Which was?
Proposing a feasible alternative method of execution, one that would actually be less painful. That's a major hurdle set by those prior rulings.
Okay, let's dig into the petitioner's arguments more deeply. Mr. Halkman, Bucklew's lawyer, what were his main points?
He really hammered home that this wasn't just any lethal injection for this client. With this condition, it was almost guaranteed to cause severe harm, right from the get-go, trying to set the IV line all the way through.
And didn't Justice Sotomayor bring up his tracheostomy? Like the recent surgery he'd had?
Yes, she asked if that might actually lessen the risk of him choking on his own blood, which was a big fear raised by Bucklew's team.
Fair question. How did Hochman respond?
He acknowledged the track, sure, but said, look, nobody's actually studied how that interacts with potential bleeding during this specific procedure, the execution protocol. Plus, he added, we don't even know for sure if the track will still be in place when an execution happens.
So adding another layer of medical uncertainty.
Exactly. And then there was this whole discussion about the expert testimony, Dr. Ziva, and his estimate on how long it would take for brain activity to stop the EEG 0 point after the drugs were given.
Based on a horse study, I remember.
Right. Hochman had to clarify some details there. He admitted Dr. Ziva initially misspoke about the exact time, but the maximum time in that study from drug infusion start to EEG 0 was about 3 minutes.
3 minutes.
Yeah, and he pointed out the infusion times varied a lot in that study. And the state's own expert, Dr. Antonini, agreed a slower infusion would mean a longer time for the drug to work. Plus, the dose in the horses was way higher, relatively speaking.
Then the Chief Justice jumped in, right? Roberts.
Yeah, he asked, basically, why does EEG 0 matter so much here? In major surgery, doctors don't wait for brain death before they proceed. Why the focus?
Good point. What was the answer?
Hochman explained the issue wasn't just the time to brain death itself, but the unknown period before that. When exactly does consciousness fade? What are the stages? He argued there's no solid research on that specific transition during lethal injection.
So the concern was about potential awareness and suffering during that transition period.
Precisely. Justice Alito pushed back, asking why it wouldn't just be a quick process. But Hochman stuck to the point. We don't know, and that unknown period is where the constitutional risk lies.
Okay, so beyond the drugs themselves, Hochman also focused on the process before the injection, right? Getting the 5E line started.
Absolutely critical part of his argument. He stressed the difficulty they'd likely face finding a usable vein because of Bucklew's condition, which could force them to do a cut-down procedure.
A cut-down, what does that involve?
It's basically a surgical incision to directly access a deeper vein, in this case, potentially the femoral vein in the leg. Testimony suggested it could take, 15 minutes or even longer.
While he's lying flat. That sounds incredibly stressful, especially with a throat tumor.
That was exactly Hoffman's point. It could cause immense stress, potentially triggering airway collapse. He also noted that Missouri had used a cut down before when they couldn't get peripheral access on another inmate. The kid even had the tools for it.
But the state's expert said a good anesthesiologist could probably avoid that.
Dr. Antonini did say a board-certified anesthesiologist could usually access the femoral vein without a cut down. But Hoffman countered by pointing out that the specific anesthesiologist scheduled for Bucklew's execution had performed a cut down on an inmate's femoral vein previously.
So whose prediction do you trust?
Right. Hoffman suggested that if they'd had more discovery, more information about the specific medical team members, they might have found other ways to get venous access. He also flagged the lack of ultrasound guidance, which is pretty standard in hospitals for femoral access.
So the argument was, even if Missouri follows their protocol, it's still likely to cause severe suffering for Bucklew.
Yes, and that ties into the Baze requirement proposing an alternative. Hoffman argued that an alternative method doesn't have to have been used before to be constitutionally reasonable.
And he stressed this was an as-applied challenge.
Crucial distinction. He wasn't saying lethal injection is always unconstitutional. That's a facial challenge. He was saying, for this specific person, Mr. Bucklew, with his unique medical issues, this method would likely cause unconstitutional suffering, even if done correctly, according to the state's plan.
So what did he ask the court to do?
Vacate the lower court ruling and send it back down, remand it. He argued things had changed, like the tracheostomy, and they needed more time to explore alternatives, maybe modifications or even lethal gas, which they mentioned earlier.
Okay, makes sense from his perspective. Now let's switch gears. Missouri's lawyer, Mr. Sauer. How did he respond?
He came out swinging, basically saying these predictions of, horrific outcomes were just wrong. He claimed the evidence in the record contradicted Bucklew's claims at every single stage.
Like what specifically?
He pointed to testimony saying the execution gurney is adjustable, the anesthesiologist can position the inmate for their medical benefit within the protocol's limits.
And that the medical team would know about the condition.
Yes. Sauer assured the court the anesthesiologist would have Bucklew's full medical records, including that specific summary about the hemangioma.
What about the idea of sending it back for more fact-finding?
Sauer strongly opposed that. He argued it would just be more delay for a sentence that was already over 2 decades old. He felt the existing evidence was decisive and the lower court got it right. Affirm.
And he hit hard on the Baze precedent, the alternative method requirement.
Absolutely. He emphasized the court's own words from Baze that a completely untested, untried alternative isn't reasonable.
Did he think that should apply even in an as-applied case like this?
Yes, he did. He argued that if you didn't require an alternative, even in these specific challenges, you'd basically create ways for inmates to get de facto exemptions from the death penalty just by challenging the method without offering a solution. He brought up Hill v. McDonough and the reasoning from Baze and Glossip.
That led to a pretty intense exchange, didn't it, about the scope of the Eighth Amendment?
It really did. Justice Sotomayor pressed him, doesn't the Eighth Amendment protect individuals? Sauer agreed, yes, but argued the scope of that right for execution methods is defined by Baze and Glossip, meaning you have to propose the alternative.
And he went pretty far with that idea, suggesting even a gruesome method might pass muster if no alternative was offered.
That was the striking part, yeah. He essentially argued that if a method caused, say, gruesome and brutal pain, but the inmate didn't propose a known, feasible, less painful alternative, the state could still proceed.
That really shows how central that Baze requirement was to Missouri's argument.
Wow. So alternatives like firing squad, which Bucklew mentioned.
Sauer noted Bucklew only mentioned it in a footnote, didn't formally request it, and it wasn't authorized by Missouri law anyway. Though Sauer did say Missouri hadn't taken an official position on whether state authorization was strictly necessary for an alternative.
So deference to the state and its officials was a big theme for Sauer. Huge theme. Deference to the state legislature in choosing methods, deference to the prison officials implementing them, and especially deference to the on-site board-certified anesthesiologist making medical judgments. He insisted the records showed they had offered to adjust the gurney.
And he disputed the idea that severe suffering was inevitable, even if the protocol was followed.
Right. He leaned on Dr. Antognini's testimony, the state's expert, who said the only predictable suffering was the standard stuff. The IV needle poke, maybe pain from a cut down if needed. But Sauer also downplayed the cut down risk, saying the previous instance was on a different vein lower down.
Did Sauer give reasons why the alternative requirement is so important?
He laid out 4 main reasons. 1, the logic and holdings of Baze and Glossip. 2, the death penalty itself is constitutional, so there has to be a way to carry it out. 3, the suffering concerns in Baze were actually broader than here. And 4, the risk of just endless lawsuits simply to delay things.
Suggesting Bucklew's real goal was just delay.
He implied that, yeah, pointing to repeated challenges as evidence.
Okay, so then Hochman got a chance for a rebuttal, right? Last word.
Yes, a brief rebuttal. He picked up on something Justice Kagan had said, that surely no state wants to design an execution method that causes the kind of suffering Bucklew feared.
So his point was?
That the alternative requirement puts the burden in the wrong place. If the state's method creates this high risk of cruel pain for this person, why should the inmate have to invent their own execution method? It seemed fundamentally unfair to him.
He went back to the core of the Eighth Amendment.
Exactly. The amendment flat out prohibits cruel and unusual punishment. He argued the duty to avoid that rests with the state, primarily. It shouldn't hinge solely on the inmate finding an alternative.
Did he concede that any execution involves some pain?
He did. But he argued that in an as-applied challenge like this, where the likelihood of severe specific suffering is so high, you have to compare the state's method to potential alternatives, even ones Missouri hasn't approved, like firing squad, to really judge if it's cruel and unusual for this individual.
Okay, that really maps out the core clash between the two sides, a very complex intersection of law, medicine, and constitutional rights.
Definitely. You can see the tension between established legal tests and unique, challenging facts.
Right. Which brings us perfectly to our 10th chair segment. If we were sitting as that hypothetical 10th justice, how would we approach this?
Well, you really feel the weight of precedent here, don't you? Baze and Glossip set a high bar with that alternative method requirement. It clearly shaped how Missouri argued the case, and likely how the majority viewed it.
It did. But that exchange about gruesome pain potentially being okay if no alternative is offered, that's deeply troubling from an Eighth Amendment perspective. It feels like it elevates a procedural hurdle over the fundamental right itself.
I agree. If I'm in that 10th chair, I'm wrestling with that. The Eighth Amendment feels absolute no cruel and unusual punishment. Does forcing the condemned to propose their own less painful death adequately protect that right, especially when the state's chosen method seems uniquely agonizing for that specific person due to a rare medical condition?
It feels like it could create a loophole. What if a truly less painful alternative exists, but it's not currently authorized by the state, or maybe it's novel? Does the inmate just suffer unconstitutionally because they couldn't meet?
It's a difficult balance. The state does have a recognized interest in carrying out lawful sentences. But that interest surely can't override the Constitution's absolute prohibition on cruel and unusual punishment. Cases like Bucklew really force us to confront where that line is drawn.
A profound question indeed, and one that continues to resonate in debates about capital punishment. That's all the time we have for this deep dive.